After their sentencing, the Lovings were forced to leave Virginia and decided to relocate to Washington, D.C. During this time in exile, they raised 3 children, sons Sidney and Donald, and a daughter, Peggy. They attempted to make a life for themselves in D.C., but they never really felt at home. Mildred was a country gal through and through, and she never fully adapted to city life. She missed the countryside where she'd had plenty of room to run around as a child. Missing their families, the Lovings defied the court order on multiple occasions in order to go visit relatives back in Virginia. On these trips, they took extra care never to be seen in public together. Richard very often just wouldn't leave the house while they were there. But even these secret trips home couldn't satisfy the Lovings. Their entire life was in Central Point, Virginia, including their family and closest friends. Mildred and Richard longed to return to their hometown for good. Feeling empowered by the civil rights movement, in 1963, Mildred desperately wrote a letter to U.S. Attorney General Robert F. Kennedy asking for assistance. Kennedy referred her to the American Civil Liberties Union, which agreed to hear their case. November 6, 1963. With the help of ACLU lawyers Bernard Cohen and Philip Hirschkopf, the Lovings filed a motion in the state trial court asking Judge Bazile to vacate their conviction and set aside their sentences. After almost a year with no response, they brought a class action suit to the U.S. District Court of the Eastern District of Virginia, which finally produced a response from Judge Bazile. Bazile refused to vacate the conviction. Cohen and Hirschkopf then took the case to the Virginia Supreme Court of Appeals, which also upheld the original ruling. However, the appellate court did void the Loving sentences because they viewed the conditions under which they were suspended as, quote, unreasonable, unquote. The Lovings secretly lived on a farm in Virginia for much of their legal battle. They had considered living in separate houses, but their lawyers assured them that even if they were arrested, the ACLU would be on call to have them released within a couple of hours. Life magazine photographer Gray Villett visited the Lovings in 1965, before the case made its way to the U.S. Supreme Court. His assignment was to document the day-to-day world of the Lovings and their children. The photos Villett took ran in a 1966 issue, and they provided an intimate look at a couple who would go on to change history. The case eventually made its way to the U.S. Supreme Court and was scheduled for argument on April 10, 1967. The Lovings' attorney, Philip Hirschkopf, was only 2 years out of law school, so he did not meet the qualifications to try a case in front of the Supreme Court. This meant that everything Hirschkopf wrote had to be signed off by Bernard Cohen, who had been out of law school over 3 years. It should be noted that neither of the young lawyers had any previous experience in federal court. Before the oral arguments began, Mildred was asked what her thoughts were on the case. Quote, "It's the principle. It's the law. I don't think it's right. If we do win, we will be helping a lot of people. I know we have some enemies, but we have some friends too. So it really don't make any difference about my enemies." Unquote. Neither Richard nor Mildred appeared in court for the oral arguments, but Richard sent a letter to the justices that read, quote, "Tell the court I love my wife, and it just is not fair that I cannot live with her in Virginia." Unquote. Virginia's Assistant Attorney General Robert D. McIlwain III defended the constitutionality of Virginia's anti-miscegenation law, comparing it to similar regulations against polygamy and incest. Cohen and Hirschkopf argued the Virginia statute was illegal under the 14th Amendment, which guarantees all citizens due process and equal protection under the law. Hirschkopf stated, Virginia's interracial marriage law and others like it are rooted in white supremacy and racism. Quote, "These are not health and welfare laws. They are slavery laws, pure and simple." Unquote. The Supreme Court announced its ruling on July 12, 1967. The justices unanimously decided that Virginia's interracial marriage law violated the 14th Amendment. This overturned the Pace v. Alabama ruling of 1883. Chief Justice Earl Warren wrote, quote, the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. Marriage is one of the basic civil rights of man, fundamental to our very existence and survival. To deny this fundamental freedom on so unsupportable a basis as the racial classification embodied in these statutes, classification so directly subversive to the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state's citizens of liberty without due process of law. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state." Unquote. This was a landmark ruling. Not only did this ruling overturn the Lovings' 1958 criminal conviction, it also struck down remaining laws against interracial marriage in 16 U.S. states, including Virginia. Some states dragged their feet when it came to altering their marriage laws. The last state to officially accept the ruling was Alabama. It took until the year 2000 for them to remove an anti-miscegenation statute from their state constitution. In total, the Lovings' whole ordeal from their arrest until the Supreme Court's decision lasted 9 years. After the Supreme Court's decision, the Lovings were able to return to their hometown of Central Point, Virginia. Richard built a home for his wife and children just down the road from his extended family. Richard Loving was tragically killed in 1975 when a drunk driver ran a stop sign and struck the couple's car. Mildred survived the car crash, but she lost the sight in her right eye as a result. Mildred spent the rest of her life in Central Point. She lived a quiet, uneventful life and did her best to stay out of the public spotlight. On the 40th anniversary of the Loving v. Virginia ruling, 3 people from the gay rights group Faith in America came to Mildred to ask her thoughts on same-sex marriage. It was unclear what her answer would be, considering Mildred was devoutly religious. After taking some time to reflect and having discussions with her neighbors and children, Mildred issued the following statement, quote, "I believe all Americans, no matter their race, no matter their sex, no matter their sexual orientation, should have the same freedom to marry. Government has no business imposing someone's religious beliefs over others, especially if it denies people civil rights." Unquote. Mildred Loving died of pneumonia on May 2, 2008, at the age of 68. She never remarried. Richard and Mildred were very much reluctant heroes. They were both reserved individuals who never felt the need to draw attention to themselves. Loving v. Virginia has proven to be one of the most significant legal decisions of the civil rights era. Ending prohibitions on interracial marriage dealt a major blow to segregation and its supporters. Loving v. Virginia has been invoked in subsequent court cases concerning same-sex marriage. June 12th, the anniversary of the Loving v. Virginia decision, is now an unofficial holiday celebrating multiracial families. On June 2, 2018, Caroline County unveiled a historical marker honoring Mildred and Richard Loving. The marker is located in a triangulated location between 3 important locations from the Loving story: 11 miles west of the home Richard built for his family, just south of the Bowling Green jail where the couple was held, and 40 miles north of the former site of the Virginia Supreme Court of Appeals. In 1967, only 3% of U.S. marriages were between people of different racial or ethnic backgrounds. As of 2015, 1 in 6 newlyweds in the United States has a spouse of a different race or ethnicity. Public opinion on interracial marriage continues to improve as well. In 1990, a Pew study indicated that 63% of non-Black adults said they would be very or somewhat opposed to a close relative marrying a Black person. As of 2017, that figure had dropped to just 14%. That wraps up our episode on Loving v. Virginia. Thank you all so much for listening. Be sure to check out the Salacious History page on Facebook and follow us on Twitter. Our handle is @SalaciousHist. That's SalaciousHist. If you enjoyed today's episode, consider leaving a rating and review on Apple Podcasts. It really helps to get the word out about the show. Remember to head over to patreon.com/salacioushistory to sign up for special rewards and help support the future of this podcast. If you have corrections, funny stories, or ideas for future episodes, you can email me at salacioushistory@gmail.com. I'm Sarah Duncan. See you next time.